go over our agenda. I'll do brief introductions, and then we'll go over traditional security risks for lawyers, how technology has changed these risks, state requirements, underwriting cyber liability, and then finally we'll open it up to questions and answers. My name is Jason Adams, and I am the National Production Underwriter for McGowan's LPL division. I am responsible for underwriting and distribution of the LPL program for McGowan, and I have 10 years of experience concentrated in professional liability insurance. Neil McGowan is the other presenter, and he is responsible for managing all professional liability programs at McGowanPRO. He joined McGowan in 2011, manages underwriting operations for a large insurance MGA, and private practice he was in prior practice prior to the insurance career, and he received his JD from Cleveland Marshall College of Law in 2011, his MBA from Aluja College of Business in 2011, and his BA from Connecticut College in 2007. He is also licensed in Ohio. And now I will allow Neil to discuss traditional security risks on our next slide.
So I also want to thank everyone for joining the webinar series today and for attending. As Jason said, the goal of today's webinar is really to introduce you to the risks that some lawyers face, really with regards to cyber liability and professional privacy issues. So we'll discuss how in some aspects the current risks have not changed from traditional security risks, how in many respects they have changed, what that risk can look like, and how devastating a cyber claim can be. Finally, in today's webinar, I'm going to introduce you to how McGowanPRO and Zurich see cyber liability for lawyers, how we handle the risk, and how we underwrite to the risk. So let's start with the traditional security risks. Legal malpractice occurs when an attorney breaches the standard of care, and that breach of the standard of care is the proximate cause of an injury to the attorney's clients or to a third party, such as the beneficiary of an estate. Breaches can be any number of affirmative actions. They can also arise out of the failure to act appropriately. So in regard to privacy liability, one of the duties of the standard of care is that an attorney has the duty to take reasonable steps to protect his or her client's properties. And if an attorney loses that client's property or wrongly permits an unauthorized person or entity to access the client's property and it causes injury to the client, then the attorney can be held liable for those injuries. Another duty is that every attorney has the duty to keep their client's identity and information confidential without informed consent. There are exceptions to the rule, so you have to be required to divulge it for certain legitimate purposes. But for decades, complying with the standard of care basically meant that you locked your doors, you locked your cabinets and desks, you had an alarm system, and that meant the data was safe and you knew when someone was trying to access the data. In addition to the rules and duties set forth by that standard of care, almost all states follow the model rules of professional conduct, which have two distinct rules, Rule 1.15 and Rule 1.6. They're applicable to the issue of privacy rights. Rule 1.15 is the duty to safeguard a client's property, and Rule 1.6 covers the attorney-client relationship and requires the insured to refrain from revealing information relating to the representation of a client unless the client gives informed consent or the disclosure is authorized in order to carry out the representation. So the rule sets out the applicable standard of care stating, a lawyer shall make reasonable efforts to prevent the inadvertent and unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Violation of these rules does lead to various types of claims. Some of the claims we see from that, violations of attorney-client privilege, theft of client property from an office or car. This can include losing original documents, client's valuable physical property, and intellectual property. And we also see spoilage claims coming out of this traditional area. And that basically means that because the evidence is no longer available, the party who lost the piece of property may not submit evidence regarding the property. So a violation of the model rules of professional conduct can lead to a disciplinary proceeding. The attorney's license to practice law can be suspended if the court feels that he or she has violated those rules. What's interesting is the Zurich LPL policy we offer contains coverage for the defense of disciplinary proceedings. Subject to the terms of the policy, we'll actually reimburse the insured for the cost of defending a disciplinary action up to $25,000. So in addition to the disciplinary side of things, a client can sue for legal malpractice because the loss or improper access to file can affect an underlying case. And we actually have some real-life examples of this where critical evidence has been in a file that's unavailable at trial. The file can contain valuable documents such as bearer bonds and the losses on the attorney. The insured's file can contain client's intellectual property. And basically, when it comes to this, to the rules of professional conduct, a violation can actually constitute negligence per se. So the proof of the violation of the model rules is the prima facie evidence of the breach of the standard of care. The plaintiff yet still has to prove the breach of the standard of care caused the injury, but it is prima facie evidence in a lot of cases. So now that we've taken a look at the traditional risks, we're going to discuss how technology has changed the risks for attorneys. So essentially, before computers, in order to get this information, violate this data and privacy, the bad guys actually had to be physically present in the office. And the size of the data being taken was limited to the size and quantity that you can carry. Before computers, the bad guys would need to know how to find the documents, and there would usually be evidence of the break-in. And we didn't have these smart devices which acted as unsecured backdoors to computer networks. The only crazy gadgets we really saw were in James Bond films. Clocks were clocks, thermostats were thermostats. This changed. With the advent of computers and computer networks, the limitations essentially disappear. So they can be accessed anywhere in the world with a computer and an internet connection. The size and the quantity of the documents are only limited by really the speed of the connection you have and the size of your hard drive. In addition, in the past, in order to find information, someone who broke into an office would have to leaf through files. But nowadays, you can actually just search it through the volumes of data. In addition, a hacker can be in and out of the computer network without the attorney ever knowing that he was there. So finally, every year we connect more and more devices to our computer networks, whether those are locks on doors, security cameras, which a little bit of irony there, refrigerators, and so on. So your network is only secure as the weakest link. And interestingly enough, this is a major concern for us when it comes to IoT devices. That's Internet of Things. So this includes any non-traditional Internet device, TVs, thermostats, clocks, fridges. They're not traditional Internet devices in the sense of the word, so they have far fewer security protections, and that leads to major vulnerabilities. One of the most well-known ones that probably people remember was a botnet attack, which linked all of these IoT devices to shut down a huge portion of the Internet back in 2016. I myself actually have a smart thermostat, which can, I access remotely to raise and lower the temperature in my house and in my office. But as it turns out, there was a major security flaw in it, which, if it had gone unpatched, would have allowed an online attacker to remotely access my network as though he were sitting at my computer like I am today. And while a lot of people don't handle confidential information, attorneys do, and those devices are targeted as access points for blackmail and to manipulate the outcomes of cases. So I'm going to hand over control over to Jason to discuss why these data breaches are such a big deal.
Okay, thank you, Neil. How big of a deal are data breaches? And I'd like to kind of footnote this by saying that these are significant examples, and I promise we'll bring this back full circle and how it relates to you. Moving on, I think we've all seen the headlines related to the companies shown within this slide. You have Yahoo, which the breach affected 3 billion users. The company recently offered just under $118 million settlement. You have Equifax, had 145.5 million users who had sensitive information exposed. LinkedIn had nearly 167 million users compromised. And Target, finally, who had nearly 41 million customer payment card accounts affected, and as many as 70 million people having other personal information compromised. So it's it's very widespread, obviously, and more significant for these larger companies. Next slide. So what is the impact of these data breaches? As you would imagine, businesses will suffer in several ways subsequent to a data breach. Customers lose confidence in the brand and business and don't feel that their data is secure. With all other factors aside, this can cause 4% abnormal customer churn. This also turns away potential new customers. In 2018, the total average cost of a data breach was about $3.9 million, up nearly 7% from 2017. With the U.S. having the highest average notification cost of around $740,000, the U.S. also has the highest indirect cost per record, approximately $152 per record. So there definitely can be a positive correlation made between the time it takes to contain the breach and the total cost of the breach. So as you can see, it's clearly important to have good controls in place. Next slide, please. So how does this relate to an individual attorney or law firm, and what are the types of data breaches that a law firm could experience. First is ransomware. A good example of this is the Baltimore city government and the attackers seeking 13 Bitcoin to release the information. Inside information.
And I'm just going to jump in there in case people don't realize how much a Bitcoin is. It used to be that you could get a Bitcoin for $100, but at one point last year it was up to around $20,000. So when they're saying 13 Bitcoin, they're talking about a significant chunk of change. Sorry about that, Jason.
Yeah, no problem. So inside information, user area, phishing attacks. Most of you probably experienced this method of trying to gather personal information using deceptive emails or websites. Hacktivism, this can particularly be problematic for lawyers representing controversial individuals. And finally, loss of mobile devices. We've found 1 in 3 organizations admit to suffering a compromise due to loss of a mobile device. Many professionals still don't have mandated measures to access secure information, and there's still an alarming amount of individuals not using passwords, PINs, or biometric security. Next slide, please. So I want to give you real-life examples of data breaches at some of the law firms, that we've recently seen. Here are 4 examples of LPL claims that we've been involved with. Example 1 is a large law firm that was hit by malware, which spread through their network and deleted all of the data on many of their hard drives. Their IT department was required to work 15,000 hours to replace their data. Example 2 is a criminal defense law firm which was representing an Army sergeant who was alleged to have committed war crimes in Iraq. Hackers committing what is known as hacktivism hacked their computer network and stole 3 gigabytes of the firm's data. Example 3 was a law firm that had an attorney who left an unencrypted laptop on a train. The client contained information concerning the client's customers. The company paid the insured $350,000 to provide credit monitoring services to all of the bank's customers. Bear in mind, this payment was not made, and there was no evidence that the computer was ever used or the data was accessed. And finally, example 4 was a law firm which was hit by ransomware on their network drive. The firm, in order to access their own data, had to pay a ransom to hackers. Ransomware is very tricky because if you get if you don't get your data back, you don't know if the data was accessed, copied, etc. You still need to notify clients who may have been compromised of the loss of data, and you don't know if there will be an actual claim in the future. With that, next slide, please. And I'll let Neil go over state requirements.
So, in addition to the standard of care and the model rules of professional conduct, essentially every state has enacted its own statutes and laws regarding individual privacy rights. The states focus on both the right to privacy and for protection for consumers, and that typically comes with extra duties to notify impacted customers. So these rules apply to all businesses which obtain and hold customers' personally identifiable information. You're going to see that a lot in the cyber contracts. It's called PII. The definition of personally identifiable information traditionally includes names, health records, social security numbers, but it's continuing to expand. It now includes, in a lot of states, passport information, bank account information, transaction histories, credit card numbers, employment information, insurance, the list goes on. Kentucky even expanded it to include fingerprints, photos, tax and disability information. So the state privacy laws focus on safeguarding data and generally require, and the key here is they require reasonable measures. And reasonable measures are the same standard as the model rules of professional conduct and the standard used for the standard of care. So now we come to the question of how do McGowanPRO and how does Zurich see cyber as it relates to lawyers? So unlike many underwriting companies out there who exclude cyber and privacy coverage, we essentially view cyber as a modern evolution of a lawyer's standard responsibility, the traditional responsibility to protect clients' data and privacy as a measure of the standard of care. So the duty to protect a client's data is the same today as it ever has been. Every attorney has the duty to protect his or her client's property, whether it's tangible or if it's in electronic form. The hazards involving this duty, however, have really changed with the advent of computers and computer networks. So we require, in order for coverage to be applied, our insureds to take reasonable steps, and these steps are steps that every attorney can take to protect their client's data. So if the firm takes these reasonable precautions, McGowanPRO and Zurich include cyber liability coverage up to the limits of the policy, which unlike other LPL policies, we don't supplement this coverage. So you'll see a lot of policies out there with exclusions or some policies which claim to cover cyber liability, but then only provide $25,000 or $50,000 in defense costs, which really, as Jason explained, only scratches the surface of these potential costs. So more importantly, our policy will cover you for both the alleged violation and the malpractice allegations. Some of these other companies, if there's a complaint that alleges both a violation of security, privacy rights, and malpractice, the carrier may decide that it only covers the security, privacy coverage, and then it won't cover the malpractice allegation. On the other hand, if the firm does take reasonable precautions to protect his or her client's data, we'll cover it. If they don't, we're going to add 1 or 2 exclusions based on the answers on the application. So really, here's the key. McGowanPRO wants our insureds, our attorneys, to be aware that cyber liability risk, what the risk that it represents, to be aware of the standard of care as it relates to his or her client's data and to client's privacy and to comply with the standard of care. We want you to understand that it's relatively easy to comply with the standard of care, and we want you to take appropriate precautions to protect your client's data. And now I'm going to hand this back to Jason to explain what those basic steps are.
Thank you. So what we've done here is we've actually taken a screenshot of this section of the application that covers the information. So I'm going to go over these one by one and show you how straightforward and easy it is. So you have question 35. Basically, we want to confirm that applicants are protecting written information or electronic devices that could be physically compromised. So this is very basic. We're talking locking systems, nightly alarms, etc. Question 36, the applicant is using standard protection measures for computers. We want to see that they have a firewall in place, virus protection software, and intrusion detection systems. And then question 37, we want to confirm that the applicant updates virus definitions automatically or daily. Next slide, please. Question 38, the same for operating systems and application software. We want to see that these are updated automatically as recommended. Question 39, we want to confirm the use of strong passwords. And then finally, the final 4 questions there, we want to confirm that encryption measures are being taken for both computers, emails, mobile devices, and routers. And I want to footnote this again by saying many of our insureds, don't realize that these are very simple steps. For example, emails, many of your major providers like Gmail, they already encrypt your emails, and the same for mobile devices. iPhones are already encrypted. So we just are looking to confirm these things and make our insureds aware of it. Next slide, please. Okay, so we will require the applicant's loss history with regards to privacy data breaches and concerns. And lastly, we want to confirm that backups are being performed daily. The backups should be stored securely off-site, and the cloud is perfectly okay. And I'd like to kind of bring this full circle and into perspective with an example of how simple it can be to provide a minimal standard of care to an applicant's client and how that can go wrong. I'd like to note that in reference to the Baltimore City government incident, the ransomware worked only because city computers had not applied free available software patches. And I'd like to repeat, those are free patches that are available, just like I talked about on the previous slide. Those should be updated either automatically or daily, and we're operating without effective backups. So 2 very simple things that we look for, and you get coverage within our policy form. These are samples of issues that we are seeing with insureds and why we're requiring these protocols to be in place. With that, I'd like to turn it back to Neil to review standard of care on the next slide.
So I'm going to try to make this one as simple as possible. McGowanPRO and Zurich are really simply asking our insureds to be at the standard of care, not necessarily above it. If you are at the standard of care, you receive cyber liability coverage, no additional cost without any sort of supplement. through our policies. If you aren't, we exclude the coverage, and there's no coverage for cyber liability. But we've had a couple of questions come in. What happens if we take all the precautions but we don't encrypt the data? So we do some of it, but we don't do all of it. In those cases, what we're going to do is we're going to offer coverage for the security and privacy claims, but we'll exclude any claim that arises out of the failure to encrypt your data. So you can actually have, and we'll get into this, but there are two exclusions that we apply, which can be applied independently. So moving on, how does Zurich cover cyber liability? And the answer is Zurich identifies two areas of coverage. The first area is to provide coverage for claims arising out of security wrongful acts, which is a defined term in the policy. You're going to see it right up there on the screen. Security wrongful acts means an act, error, omission, neglect, or breach of duty committed by the insured which causes a breach of the insured's network. And the second area of coverage is the privacy wrongful acts. So it's also defined by the policy as meaning any actual, alleged act, error, omission, neglect, or breach of duty by an insured that results in a privacy event, which is also defined by the policy. So I'm going to hand this back to Jason.
Okay, so exclusions in the LPL policy. So first off, we underwrite the LPL coverage and we underwrite the security and privacy coverage somewhat separately. If you take the appropriate precautions as a lawyer, but not with regards to security and privacy concerns, McGowanPRO may still offer coverage through Zurich, but exclude the security privacy coverage. As noted above, we have two distinct exclusions. One is about security and privacy concerns in general. If you don't use strong passwords, you don't have good antivirus and updated processes, and if you don't like your doors or filing cabinets, we will exclude coverage for security wrongful acts and privacy wrongful acts. The security wrongful act, privacy wrongful act exclusion will be applied. Likewise, if you fail to encrypt your wireless network, use unencrypted emails, fail to encrypt your hard drives, or fail to encrypt your mobile devices, again, which is very easy, and most people using, Gmail or iPhones, it's already taken care of. So we urge you to just check that. We'll clearly, and if not, we'll clearly apply the unencrypted data exclusion. The insured can have one exclusion or the other, or could have both. So it all depends on the precautions that the attorney or law firm is taking. And with that, I'll let Neil finish with our final thoughts and other considerations.
Okay, so basically in conclusion, the key here is cyber liability is a large and a very real risk for attorneys. While we always encourage best practices, one advantage of the way that we view cyber liability is that it enables us to write a risk even though the attorney doesn't take all of the necessary precautions. When it's not excluded, though, the security privacy coverage is at full policy limits. We don't supplement cyber liability, and that's in contrast to many of the carriers in the market. So lastly, please note, coverage is third-party only. It doesn't cover first-party coverage, and we're not going to reimburse insureds for damage to their own computer systems. However, we will cover the cost of notifying the insured's clients and potentially their customers as well. Really, the policy we offer is cutting edge, and if you do have issues with some of your cyber liability requirements that we discussed or questions about them, we can work with you and your law firm to remedy the issues and to apply coverage in the future for those areas. So I'm now going to hand it back to Jason to discuss some of the benefits of working with Zurich and McGowanPRO.
Okay, thank you. So for those of you who are unaware, Zurich is AM Best A-rated admitted market. Zurich has been in the LPO market for nearly 25 years. It's one of the longest standing LPO programs in the country. Insurance programs tailored to fit solo and full-time and part-time attorneys, up to 99 attorneys, as well as a moonlighting lawyer. McGowanPRO is one of the longest standing firms of its type and one of the leading underwriters of professional liability. We will ensure quick turnaround time and exceptional customer service. If you have any questions, our phones, we're always accessible. You can call either me or Neil, and we'll address any concerns you have, answer any questions, and make sure you have the best coverage possible. Loss prevention hotline and access to lawyerinlaw.com is hosted by Hinshaw Culbertson. This includes 6 hours of continuing legal education, which also includes 3 ethics credits, and this can all be done online. So that's an important factor and a nice benefit to our program. 24/7 claims reporting, and insured should note that any claims that will be handled by a knowledgeable claims staff, the majority of which of the claims adjusters are attorneys, just like Neil's an attorney as well. So whether it's policy issuance or underwriting or claims handling, we have a lot of attorneys that are on staff that can assist you with your policy. So with that, I think Neil and I can open it up to questions.
All right, let's give everybody a minute to type them up. Yeah, Rob, the answer is you do have to have a policy with McGowan and Zurich to get the free continuing legal education credits. Those aren't available to everybody. It's only to policyholders. So once you write a policy with us or you purchase an E&O policy, it automatically opens up the Hinshaw-Culbertson CLEs. And I've done them myself. They're actually very, very good. They're easy to go through. So I hope that answers your question. Oh, John, that's a good one. Okay, so how do we submit applications? Jason, I'm going to leave that in your hands.
Okay, so you would send applications directly to me, and then I would distribute those amongst our underwriting staff. My email and Neil's contact information, phone number, and everything should be on the slide that's currently in front of you. So jmadams@McGowanPRO.com, where you're welcome to give us a call. And I believe we should get a list of everyone that's in attendance. So I will send out emails with our contact information so that you don't have to hunt us down.
All right, Sue, the answer is yes, we do record these, so if you do want to provide this to another member of your firm, just email us. We'll be happy to provide the link to the webinar so you can share it around. And do we have any other questions? All right, so we do have a few more. We're going to answer those offline. They get a little bit in depth. A couple of questions here were about specific claim scenarios. The answer is I can't address specific claims. Every single claim is evaluated as it comes in. So we can address coverage broadly, but when it comes to the actual claims handling, that's sent to a claims adjuster. This is something we didn't mention. One of the big benefits of working with Zurich is that all of our claims handlers, I think all but one are licensed attorneys. One went to law school. There are 21 of them. He did not take the bar. He ended up going straight into Zurich to handle these claims. So these are people who have worked in law, understand the day-to-day operations of your business. They're not going to try to, they're not going to disrupt things. They're going to do their best to avoid disrupting your practice, and they'll work with you when a claim comes in, or even preemptively if there's, we'll work with you to set those, those recommended best practices into place. Okay, with that, you know what, I'm going to take it offline. Thank you, everyone, for attending. We really appreciate it. And again, Jason, my information right up there on the screen.